So thank you very much, Professor Anjana and Professor Subramaniam sir, for having me today here for the very wonderful program. And sir is also like passed from the same place, Jawaharlal. So we used to hear about this sir. Sir was in Bahrain, Subramaniam sir, and when we joined, and then we subsequently we had an opportunity to work together in Calcutta, and since then we are in continuous touch. The topic which perspectives, research perspectives in international law, and that has been chosen. I just sir will also join, and many of you. Why international law? Almost 70 years has not uh, picked up in India or many other jurisdiction as well. I'll not say in India, but other jurisdiction also, and particularly in developing country, as a subject where students prefer to go or where students find some interest. That is the important point we have to think about. Research comes teaching also, and however, some of the branches of international law, if I have say research perspective in international law, so now for last 30-40 years, many branches have evolved. So root is remain so root is always very strong, but what we see root is root has become weak, but branches have become very strong, like intellectual property rights, international environmental law, international human rights law, and other subjects become very popular, and more or less it has acquired space in the law school, where either elective or compulsory papers are being taught on WTO or being taught in other environmental law and others. So some of the we see emergence of scholars, but the fundamental subject, the core subject, that is the public international law, the general principles of international law, the book of the Stark or Malcolm and Shah, it remains now untouched for many people. They have not touched the book. They read something on the there. So this is a big serious concern when it comes to the international law. This takes me to the what in end of the 19th centuries, Sir Thomas Erskine Holland, like Thomas Holland, so he had said that the law governing international community is at a vanishing point of jurisprudence. So he said something in 19th century. He did not say in a modern term. So he born in 1835, died in 1936, more or less 100 years. He was professor of international law. Thomas Holland was the professor of international law, barrister, and many other things. And he wrote a book also in 1898, Studies in International Law. Studies in International Law, which was published by Oxford, Clarendon Press in Oxford in 1898. So the problem which a gentleman, and then subsequently also we have Austin, he always raised this a positive morality, the international law, because there is no sovereignty, there is no government, there are a lot of things he has been raising. So doubt about the efficacy of international law and the popularity of the subject always remain uh, very weak, in a sense, everybody spoke about, and that continues. Some way we need to think about how to change the perception, because it's going to be a very important subject. It's a very relevant subject, and people have to take note of that. The second point, so the first, why subject has not. The second point, why should we read? What is the relevance of international law? When you watch one way, you see everything, then you start questioning the efficacy of international law, efficacy of international law, strength of international law. So in a sense, international law, the term international law has been coined by Bentham. He had said about the international law in 1798 or 97. Before that, it was the law of nations. So law of nations was as a subject there. So Jeremy Bentham has given the international law, and it has been preferred as an international law subject, we know. But it was also known as the law of peace and law of war, law of nations. So it's a regulating the conduct of the states. State is the subject of the international law. But if I apply today the application of international law in current situation in 2025, and that makes also me and many of us very depressed when we say international law is not law at all. It's like, no, it's not in the vanishing, it's losing its relevance. So I say it's losing relevance. In when it comes to the regulating the conduct of the war, international law is becoming irrelevant. When it application, international law irrelevancy. So I think not vanishing, it's irrelevant. Nobody bothers. No state is bothered. If you take the events of the entire for last 6 months, or yes, January onwards, the total disregard for the international law by one of the states is a common is a known factor to all of you. So we start. So you have a law. When you have a law, what is you need? You need an institutions. Law can be, even domestic law we have without institution, without police, without court, institution, if it's not there, law will irrelevant. So when international law is there, you must have international institution for the implementation. They will have a mandate. And of course, as you know, if the trade law, then WTO is an institution. If it IPR, WIPO is an institution. If environment, UNEP is an institution. And when it talks about the international law, United Nations is the institution. For me, UN is the institution. UN has a power. But now I feel that the role of the, and hardly we see the person who has authority, who has a power, and who derives the power through the charter provisions. So charter is the United Nations Charter. It's the Bible of international law. United Nations Charter is Bible of the international law, which consists of 18 chapters. United Nations Charter consists of 18 chapters. So it consists of 18 chapters. When we talk about the international law, United Nations Charter, it consists of 18 chapters and total 111 articles. That 111 articles is your international law. It touches upon each aspect, which we'll understand one by one. And then we have statutes of the International Court of Justice, which had 70 articles and 5 chapters. So International Court of Justice, what court had? So you have a judicial institution, you have United Nations, the functioning everything. And they have a mandate to deal with the crisis, present crisis, and all crises where states are engaged. But what we see, the role of the Secretary General, role of the Security Council, role of the United Nations are not visible. They are meeting, they are discussing, but it is not making any dent. It's not making any impact when we talk about the international law. So what we are seeing, what we are witnessing, we are seeing each day, morning and evening, that the President of the United States is playing an important role when it comes to resolving the conflict between Israel and Iran, between Gaza, between India, Pakistan, which he claims and we deny, and also Congo and I think Congo and Rwanda, which he claims I have done the deal. And now he's saying that I want to say, it's virtually he has taken all of us in a new area, global trade war. So there's another, like, he's forcing global trade war. He's forcing people. Either you come to our term or face the music. Today, newspaper, like, in just a day before, the Secretary General of NATO, he met on President Trump, Mark Rutte. He is the Secretary General. And he heaped so much praise of Trump. You cannot, he calls him daddy. So he calls him daddy. You have done everything. So, like, appeasement, chamche jo Hindi mein kehte hain chamche. So that is an extreme form. He said, daddy, you resolve the crisis. You are the great man or something. And he has threatened, if India, China, and Brazil, he said, you are going to be hit. So Mark Rutte, who has nothing to do with the policy of the government of India, but he said, you all are, India, China, and Brazil, are going to be hit. You are going to be hit very hard. You are going to be disturbed very hard. If you, like, if you do the trade, if you buy the oil from Russia, Trump has also said, if you buy the oil from, so currently we are 30 to 40% oil is coming from Russia, we are buying, not from the West Asian country. And Russia, because of sanction, has a only limited option. So we are also reaping the benefits of the sanction imposed on the Russia by the Western countries, and we are looking into and that particular part. But now he said, if you continue within the 15 days, if peace deal is not achieved, then we are going to impose 500% tariff. We are going to 100% tariff. So all these factors, he decided to undo the Paris Agreement. He decided to opt out of the international criminal law. He openly challenged the entire. He has issued sanction against prosecutor of the International Criminal Court, against the 4 judges. They can't travel to the, because International Criminal Court has issued international arrest warrant against the Benjamin Netanyahu and his one person from there. So he was so upset. He said, no, it's better we sanction. So United States has sanctioned the judges of the International Criminal Court. They said they are the criminal. They are not welcome in there. So where we are heading towards, I'm happy in a sense. We were not sure where we are moving after the collapse of the former USSR in 1989 and also East European countries. Unification of Germany, which took place in India. We thought we are moving from the bipolar world to multipolar world. So we said now, because bipolar, the 19 from the time United Nations was established on 24th, United Nations was established on 24th October 1945. Within 4 years, Cold War began. A Cold War era started, 1949, which ended almost in 1989. The functioning of the United Nations, the main institution which had mandate to regulate the conduct of the state, implement the international law, make the states accountable for the wrongful acts of the state, was not very effective during the Cold War era, 1949 to 1989. So we were in the bipolar world. Then we thought we moved to the, after the end of the USSR, we thought the world become multipolar. In a true sense, the concept of sovereign equality. All nation states are equal, which is one of the purposes of the United Nations Charter, which says principles of the United Nations Charter. which says clearly the organization is based on the principle of the sovereign equality of its members. So there are four purposes. If international law has to be understood, I say we have to understood the purposes and principles of the charter. When you have a time, it may not be possible for me to go all this in 1 hour, but I suggest to understand how international law functions. It has to function according to the purposes and principles of the United Nations Charter, which gives you an entire idea. Okay, what power the Security Council can exercise. The purposes and principles of the United Nations Charter will give you an idea about the entire functioning of the United Nations. And thus, so sovereign equality we thought it will become true after the end of USSR, but that is not there. And then for many years, China was slowed down, Russia was slowed down, but Russia all of a sudden in 2011 started to recapture its lost strength and started asserting, and some extent, Obama and Biden were responsible. And there are a lot of conflicts, lot of issues there. These countries are equally responsible. There are a lot of killings also taken place. But when Trump came, he brought the like the powerful status of the United States. That is like one positive. I say ki whatever he says that becomes the law. The issue which affects all of us, is it role of the United States president to force the state how to regulate, when to end the war, how to justify, or it is the role of the United Nations as such to look into the entire war and other things. So this is the another important. So we don't know what international law. It's more in academic purposes in the classroom where we teach students state responsibility, where we teach the relationship between the municipal law and international law, where we teach about the sources of international law, where we teach about the recognition, where we teach about the refugee law and other. So whether it's only on the academic purpose international law we are studying, or it has to be really effective when it comes to the regulate the conduct of the war. Wrongful act of the state must be regulated, and that has to be only body United Nations is there. We stay here for some time, and I move the approach changing, research changing. That is important. How to make interesting, and Subramaniam sir will also agree. Unfortunately, the international law has been taught to us, Professor Subramaniam, and all others, those who have some understanding, or many young students, in isolation. It was never taught to us in an integrated approach. We have never learned international law with the constitutional perspective. How, international law will become interesting? A constitutional law teaches, he cites Visakha judgment. The Supreme Court of India uses international law, Convention on Elimination of All Forms of Discrimination Against Women. Try to interpret the obligation of the state under the Convention on Elimination of All Forms of Discrimination Against Women, and found that the state has an obligation to adopt domestic law according to the guideline, according to the Convention on Elimination of all forms of discrimination against women. Against the so court has interpreted. We have failed. We have never taught. We have never been taught. So the Supreme Justice J.S. Verma realized, okay, why not use the international law? And then he says in 10 pages judgment in 1997, he said that the government of India has failed to adopt a law according to the or stipulated and or commitment government of India has under the Convention on Elimination of all forms of discrimination against women. Since you did not apply, since you did not adopt a proper law, we are not going to look into the transformation of international law into domestic law. So we come to the conclusion, if the international law are consistent with the constitutional provisions, we will not hesitate to implement that. So that the constitutional law teachers teach in the class, that Supreme Court had said the application of international law is not based on the executive measures. For them, they apply on the similarity between the international law and constitutional. That makes interesting to the students. When you do the research, also if you put the cases decided by our court, that makes your study interesting. Simultaneously, you are learning international law and also thinking about the state's obligation under human rights instrument and other instruments also. So learning becomes a complete. So when you teach only the transformation of international law, when you teach relationship between municipal law and international law, only how monism and dualism system, that will not make much sense. But when you start with the interpretation and application of this relationship between international law and municipal law, that will make you very different perspective, and you may be able to generate interest. It helps me also. So when I look into the cases, I always feel thrilled to look into the cases, and then I say the teaching is there. We have citizenship issue. All human rights is nationality issue. We have international law full of instruments in nationality, but nationality ultimately determined by the state government. International law also duly recognizes the importance of national system. It's not coming into the conflict. The primacy of the local system, domestic system is also recognized. There is no doubt. International law not intend to overpower domestic law. It has add when you are two states are fighting, which law should be applicable. So basically, international law aims to regulate the conduct of the state. You have to work on certain framework. For example, we can find out an answer. India and Pakistan for limited days attacked each other. Now the question about the legality of attack. If I ask you what position international law as you take, you will have a justification. Many people will say, because Pakistan is helping terrorists, they are harboring the terrorists, and we have a right to attack. But this statement may be rhetoric. This statement may be provocative, but there is no valid ground. So as an international law teacher, you have to find out everything your answer from the United Nations Charter. Of United Nations Charter, if you read one of the principles, Article 2, Paragraph 4, which clearly states the use of force is prohibited against the territorial integrity and political independence of a sovereign state. An independent reading of the Article 2, Paragraph 4, which says use of force is prohibited against the territorial integrity and political independence of a state. So no state has authority to attack another state. There is no power. So there is no justification. So this act becomes illegality. Now you might have also seen in television the foreign minister of Iran, when Israel attacked, so they retaliated. So Israel violates the international law, Article 2, Paragraph 4. We don't need to go India and Pakistan war, but Israel attacked. And I have told you, and many of you are aware, that Article 2, Paragraph 4 doesn't give anyone power to attack a sovereign state. But Iran also retaliated. When Iran retaliated, the foreign minister he used, he said, we have a right to self-defense. So Iran argued their action is based on right to self-defense. Again, as a scholar, you have to search right to self-defense under the United Nations Charter. So as a teacher, I have told you Article 2, Paragraph 4. Then when you start looking into Charter, so I said in isolation, if you read Article 2, Paragraph 4, then it's become absolute, fundamental, just cogence, peremptory norm. Use of force is prohibited under international law. Means no deviation, no movement from there. But when you read Article 2, Paragraph 4, in conjunction with Article 51 of the Charter, if you read Article 2, Paragraph 4, in conjunction with Article 51 of the United Nations Charter, your interpretation will be different, because Article 51 gives mandate to a state to defend herself. So right to self-defense is mentioned under the Article 51 of the Charter. But the right to self-defense is also based on the proportionality, doctrine of proportionality. If you are attacked for the one place, you can't demolish the entire country. Proportionality is equally important, which domestically and international also doctrine of proportionality, doctrine of humanity, doctrine of distinction. These are the important doctrine, even the international. So you have a right to self-defense. The another deliberation which required whether right to self-defense is indefinite or it's a limited. So when a reading of the analysis of Article 51, you say it limits, it gives you a power for a limited or short period of time right to self-defense. The moment matter cease to the Security Council of the United Nations, Secretary General of the United Nations, your right to self-defense cease to exist. Means a state has an obligation. You have we have been attacked. We took some measures on the ground of right to self-defense, but now this matter has been placed before the United Nations to take. By examining these 2-3 articles, what we have come to the conclusion, we started noticing there is a role of the United Nations in entire exercise when it comes to the interpretation and application of international law. Both law also in general, United Nations Charter is a general. So it gives 100 article. Every question you have, you will find an answer. And then you have a specific treaty. So it's a Bible of international law. So you know that United Nations Charter, the more you read, you will find who can use the force, who can stop the war, what is the role of Security Council, whether enforcement measures, lot of things you will find chapter 6, chapter 7 of the United Nations Charter. You don't need to worry about that. So that clarify the application, and that will help you application of the international law in general when you have a serious understanding of it. The reason for bringing this topic here was largely to make you familiar. This has lost its relevance in today's context in 2025. And because of the role which has been going, a role which has been played or which has been played by the United States. United States dictate. Now he says, 50 days I'm giving time to Russia, enter in deal. So he talks about the deal. And that is the unfortunate aspect where the states are not recognizing. It would have nice states like played important role, requested the United Nations to take a special step in this crisis. But I personally feel the persons who work in the United Nations, they are in the they are in a real sense international civil services. They are in the member of the so they are enjoying their life. They can move around, off and on, make some statement, and then disappear. So they are also enjoying life as an international civil servant, like the bureaucracy in India. So international bureaucracy, they are not playing their role in stopping the crisis. They are not playing the role in timely intervening. They did not play a role when on 7th October 2023, they could have forced the Hamas to you release all the hostages. The crisis would have been different. They focused more on the humanitarian aid and allowed the war to continue. Humanitarian, like why you are allowing people to be killed? You negotiated. The international law is based on the, it's a somewhere you can say it's a like supported and supplemented by the international institution, international diplomacy, international politics, and international organizations. There are combined. It's not in a solo. You read international law. You have to have, in diplomacy is important. The Secretary General of the United Nations could have thought about how to convince the Hamas to release 270. That could have saved thousands of life in the Gaza. But you still continue to focus, devote time on the humanitarian aid. You say, hey, so means you kill the people or you give the humanitarian aid every day. Let the Israel continue to attack, but you allow them the humanitarian assistance. People are dying, but people are getting food and water. So you focus on the humanitarian aid. And unfortunately, that has become a big part of the entire discussion. Humanitarian assistance is not. Nobody is talking except Trump. Trump is taking about release the hostage. Everybody is focusing on humanitarian assistance. And humanitarian assistance is totally controlled by the Israel. If they want, they will allow truck to move. If they don't want, truck is not moving. Let the United Nations or other people speak whatever. Humanitarian AIDS workers have been killed. But we have not targeted where the solution lies, where the crisis can end. The Hamas, like a decision to keep 270, I consider it's a big mistake. Every day if you see BBC, CNN, any channel, you feel what the mistake these young boys and girls of 3 years, 4 years have done, their parents, irrespective of their religion. Where humanitarian has lost. Humanitarian, there is no human value. There is no human importance of human lives. People are being killed freely. And this is happening in number of places there. Other day I was looking into the ICRC site. We found that ICRC has recognized that 130 countries are some kind of conflict is going on. And that is largely in the African country and nation. 130 countries in the world, according to the ICRC. They say 130 countries. And what happened, this conflict? But these conflicts are within a sovereign state. It's not from outside. So one can look into the laws applicable, international law in that perspective also. Of course, it is a lex specialis, means a special law, not the general law. Then you go into the Geneva Convention and other. But conflict has led to the displacement of the population. Today, we have more internally displaced persons than the refugees in the world. We have large number of internally displaced persons compared to the domestic law. The weakness, I'm just giving you an idea to ponder over. I'm not taking about the one by one. I'm just giving an idea how we can attempt, how can we can think about the international law, and how we can strengthen the international law according to our position, according to our profession, whatever way we can do that. I would like you to go back again to the Indian scenario, and then what I am going to highlight how international law, particularly the Indian judiciary, is addressing. We are talking about the international law. We are finding it's not. But judiciary has been playing of late very important role when it comes to the use of international law. And of course, they use international law as a persuasive value. Decision is not based on the international law. To substantiate persuasive value of international law, which has been duly recognized by the international law. Let's the case, the 20 pages case. I'll not suggest to read your 900 pages case or something. I suggest you to read couple of cases where I find a scope of the modern way of looking of the international law. Nilavati Behra versus State of Orissa. This is a custodial debt. But when come to the compensation, you'll find reference. Nilavati Behra versus State of Orissa case 1993. I would also suggest you to read Chairman Railway Board versus Chandrima Das. Justice Sagir Ahmed, I think, or P.S. Sethi, two judges bench. 10 pages, 12 pages, where he talked about the application of private law, public law, and international human rights law. And also talked about a foreign national is also entitled for the compensation and protection under Article 14, Article 21, and 25 of the Constitution. So you read that case, 10 pages case, only 10 pages. And then these three cases. If anybody is interested on the citizenship and refugee law, you read the case of Nomgyal Dolgar versus Ministry of External Affairs. Nomgyal Dolgar versus 2010 judgment. This was the case where a Tibetan girl, she got the Indian citizenship. Nomgyal Dolgar versus. There is another important case where huge references of guidelines of internally displaced person is discussed. That is, if I remember correctly, P.V. Bhatt versus Ministry of Urban Affairs, Delhi High Court judgment in 2010 by the Justice Gita Mittal. The case which I'm also like today, I made myself familiar. In fact, I came to know, but it's a 1-year-old case. That is a Rachita Francis Javier. This is the because of the case I read in the newspaper, I searched, and I thought I'll discuss about it. Rachita Rachita, Rachita Francis Javier versus Union of India. And this case was single judge bench. Justice Pratibha Singh decided on 15th May 2024. But I, honestly speaking, I downloaded today, I read it today for you to give you a different perspective. I always feel when you go in the restaurant, you don't eat every day chapati or dal and something. You try different meal. So when as a teacher you go in the class, you see that the lecture should not remain the same. What you can add, how you can make your interesting. So when you do the research and teaching, there are certain things generic which cannot be amended, which cannot be modified, which will remain there. But how to approach a subject while teaching and doing research, one needs to every day explore or every day say, "Ki, I give something new to my audience." Everything like, no, it should not become repetitive. Many times I and many of you also observe a teacher whom you have invited. The first lecture was very good. Second time you invited is very good. Third time or fourth time, by the time you see the students started saying, सर तो इससे आगे बढ़ते ही नहीं है, वहां पर ही हैं जो पहले क्लास में कह रहे। So they keep on repeating. So as like we have to innovate in the research also. You have to see there. Sometimes you think about a topic and you say ki these are the instrument fits here or not, and then you are undecided. But you can always say ki this can be fitted here. I can add here. I can add in the first paragraph, in the second part, third part, fourth part. So there are a lot of things we can do. Let's go back to the Rachita Francis Xavier versus Union of India and others. This is a single judge bench. What government of India could have not done, a single woman judge Pratibha Singh has done. She gave the nationality, she gave the citizenship to one young girl. So this is the case where she was born in India in 2006. Like you have no idea how international law comes into picture. So this Rachita Francis Xavier, born in 2006 in Nidamaru, Andhra Pradesh, said the birth taken place. She is a young girl of 19 years to a parents who earlier were Indian citizens, the parents were earlier Indian citizens and obtained US citizenship in 2001 and 2005. So means when the girl birth taken in India, both mother and father were US citizens. But birth has taken place in India in 2006. So birth has taken place in their hometown. They relinquished Indian citizenship, opted for the American citizenship. And when the woman conceived, they came back to India and they were staying in their domestic life. Since then, the girl is continued to stay in India. She did not go along with your parents. She stayed with the grandfather, grandmother, and she studied in the school. She had no idea what is her status. Whether she is an Indian citizen, she has no idea. She continued, she was going to school, registered, everything. But shock of her life, our parents got. So they said the first thing, whether a person born natural born citizenship. So birth citizenship has become big issue in United States. So where irrespective of the parents' state, the most of the states, there's a place of birth. Citizenship in many countries you can get it. United States used to have, irrespective of the status of the parents. In India also till 1986, irrespective of the status of the parents, any birth, natural citizenship it used to be. Irrespective whether they're legal, illegal, but birth takes place. But lot of factors has taken place over the years. So our citizenship amendment was amended many times. It's not the Citizenship Amendment Act has been amended in 2019. So it has been amended many occasions. And then finally, first they said, parent status is important. If birth takes place in India, then they said both parents should be legally in India. So they were legally in India, but they were not Indian citizens. This girl has. So when she applied for a passport, she was informed that she is not Indian citizen. She had visa, she was studying, she writes Indian. So passport was denied by the Ministry of External Affairs on the ground. She is not India. And government said you are illegal migrant. You are living in India illegally. So her trouble begins. Though she was very young, it's like that's not a problem. So trouble begins the day she applied for the passport. And after receiving the response from the passport office. So what happened in her state? She became stateless. Without nation, a person in India, she became stateless. So under the international law, stateless is a big subject. She became stateless. She has no place. What to do? Then she approached in the court and she approached the Delhi High Court. And so government is saying she is illegal. She has to go back from here. We'll deport her. She is illegal. But fortunately, finally the court verdict said she would not qualify as a illegal migrant. Court took as a humanitarian perspective, application of more in a very humanitarian angles, like as a good person. So she said no. And she would qualify as a person of Indian origin. The court look into. So court is not looking into the Citizenship Act, Section 21B of the Citizenship Act 1955. Court has not looked into the Indian Foreigners Act 1946. It looked on the more and the humanitarian ground, and she observed that bracketing her as an illegal migrant is not correct. It's not correct way to look into the things. So she is considered as a person of Indian origin and directed that she be granted Indian citizenship on 14th May to 15th May 2024. The government has granted citizenship in July 2024. The government has granted the citizenship. But government subsequently challenged the decision of single judge bench and said that the single judge bench has erred in interpreting the Citizenship Amendment Act. Though we have followed the direction of the court, but our request is, now this yesterday court has, Delhi High Court Division Bench heard this matter, where they said the government is Ministry of Home Affairs is saying this case should be treated as an individual case. It should not set a precedent. So government is afraid if we accept it as a, like case, and then many cases will come, similar cases. So government says no, we have given, but this case should not be treated as a precedent for the other similar cases. People will come, and that is the opposition of the government in this particular case is there. So when you read stateless, when you read for refugee, when you read the foreign national, it's a part of public international law. It's part of the branches of international law. And then you find how interesting the international law can become when we try to link the international law with the domestic law. We were under the, now we talk about the sustainable development goals. The first effort which Professor Bakshi and many of them, we have to decolonize. So what we have learned and what we're learning, so we have to decolonize the international law. Now we are talking about the new colonialism. So new colonialism, in a sense, is like without physical presence, but market regulates. So it has become new colonialism. So it's meant here for the phenomena of imperialism without colonialism. There is no physical presence, but they control economic, political aspect of the particular. So the globalization, new phenomena of globalization, it's a form of new colonialism. They are not colonized, but they have entire control of the economic and social aspect of a particular country. And then you talk about so when the newly states, nobody talks about. We had number of G77, we had NAM to represent the views of the African, Asian countries or newly independent countries. But it has lost relevance. We become very happy when we talks about we are member of BRICS, we are member of GW, G20. We hardly talk about G77. We hardly talk about the Panchshil agreement. We hardly talks about the Bandung declaration. We hardly talks about the NAM, which still continues to exist. So we were very happy that India for last 5-6 years being invited as a invited member for the G7. Why? We are not part of G7 always. But we have become a global economy. Then you have to be there, because India, there's like India, Brazil, if they are not there, European Union also become an unit, powerful unit. So they have to be there. And that is the reason they go. So we forget in our own place and commitment to raise the voice and concern of the Asian and African countries. Sir may be aware, we talk about the sustainable development goals, but we missed entirely the efforts of a large number of African countries and Asian countries, where they argued for new international economic order in 1974. So Asian, Afro-Asian countries, they argued vigorously, and United Nations has adopted Charter of Economic Rights and Duties, Charter of Economic Rights and Duties in 1974, which was a great success for the developing countries. They said, new international economic order. It's not governed by because we have come. The development word which we are talking about, we have been talking for many years. But the development, right to development as a human right, it's also started from the African country, where said, no, development is a human right. It's an inalienable human right. It's a contribution. Now, market has to run, market has to grow. So they always see, domestically or internationally, let the development focus. But development focus, even under the sustainable development goals, is largely based on economic model. It talks about the global economy. It protects the interest of the state of North. So sustainable development goals, which all of a sudden 2015, it appears like, the great support to the poor nation, but that is not there. It promotes development. It promotes the interest of the nation states from the North, developed nation, Western European countries, and others are there. Recently, if you look into the Article 38 of the ICJ statutes, or 5-6 minutes I have, so I'll just complete. The sources of international law. When we look into the sources of international law, and I'm quite sure all of you refer Article 38, 1 of the statute of the International Court of Justice. That is the place where sources of international law is there. Sources of international law means Article 31, 38, 1 of the ICJ statute. And there 31A says international conventions, when a treaty agreement is the source of international law. A. B says international custom is the source of international law. C says the general principles of law recognized by civilized nations. The C says general principles of law recognized by civilized nations. And D, it comes to the subsidiary means of the determination of subsidiary sources of international law. The subject that it says subsidiary means for determination of rules, subsidiary like writings of the scholars, decisions of the tribunals, and other is there. Even in the sources of international law, the 38(1)(c) says general principles of law recognized by civilized nations. It doesn't talk about the. So now the codification of international law is taken by the International Law Commission. International Law Commission, like say, Law Commission of India in India, the similarly International Law Commission of India looks into. So International Law Commission from 2021 onwards, working for uh, the law recognized by civilized nations need to be replaced. So there is already study going on the part of International Law Commission. And then the efforts are that the law which exists, means Article 38 1C, it should be read like, or international community must recognize, in place of civilized nations, community of nations. Means how it will read? It will read general principles of law recognized by community of nations. So the study is going, it's in draft stage, but International Law Commission, community of nations, there are a lot of critical evaluation. So they have realized why we are insisting civilized nations. So now there is effort for the community of nations. And this community of nations they have taken from the international human rights law. International human rights law, which says under Article 15, paragraph 2, Article 15, paragraph 2 of the International Covenant on Civil and Political Rights. It says uh, the general principles of law recognized by the community of nations. So this term already existed in 1966, General Principle, Article 15, paragraph 2 of the International Covenant on Civil and Political Rights. So human rights instrument identified and incorporated general principles of law recognized by community of a nations, not they have used civilized nations. So now their efforts are going on, study is going. A person has been appointed who is known as a special rapporteur. He submitted the report in January for a number of aspects. So I looked into the term civilized nations, or they are going to propose. So it may take some time, but it will happen. It also is studying the other aspects like subsidiary sources of international law is there. So just to conclude, there are immense challenges before us to may popularize this subject, and also to interpret and apply in a subject in a different perspective. It's not the Western perspective. I will not go and insist upon that you focus on third world approach. There are third world approach, first world. That's continuing. Many scholars they keep on writing third world approach. Third world approaches of international law. We must move. We have to see the how international law needs to be reformed. It's not the third world which thought about the civilized nation. It's the first world which thought about the civilized nations, and group of states thought about. And then finally they are thinking about replacing civilized nations on the community of nations. I come to the conclusion by highlighting and strengthening that one, whatever the book, Stark, Soren, or Malcolm and Shah, Bobbitt, whatever book, Bobbitt for the International Institution, a international law teacher has to understand international functioning of international organization. Law without organization, as I started, will be incomplete. And the third point which I want to add, international law, international organization, and judicial decisions of every country, whatever country you want to, Indian country you take, your study will become interesting, and maybe a student will learn and interpret international law differently from the others. Because when we talk about if I go and speak somewhere in the Canada or USA or UK, if I keep on saying international law, they are well equipped, they are well known. They say you are not contributing. So my presentation will be different or interesting to the for a larger audience when you allow to merge domestic practices with the international law, and that approach we need to follow in the class for teaching as well as the research. So thank you very much, and for for patient hearing. And if you have any question or anything, I'm happy to address. Anjana, आप
Yes,
So
sir.
I can, if anything,
The floor is now open for questions. Participants, you can type it in chat box or you can mute yourself. Unmute yourself and ask questions.
it's a 1 hour class, no? I think 3 to 4, no?
Yes, sir.
ठीक है. I think no question we can come to conclude and
So,
unmute, sir. Subhanak, sir. Uh,
sir, we have one question in chat box, sir. Who decides that proportionality aspect in respect of
State has
use
to
of force?
decide. Of course, state has to decide. You know that you have been attacked, but you know that you have been attacked like no. So proportionality is like a state. The state is like no retaliating on the self-defense. And of course, if you fail, if you like no, you did not observe, it's a self-regulation, limited power. But attacks would not completely destroy the country, and that proportionality lies on you. You have to decide. Yeah, how much, because you have been attacked, how far you can go, that proportionality. If you violate, that it will be considered as a like illegal act under international. The spying piece, what is your take? Yeah, like that's common. Nobody bothers. I think the when signing peace treaties, and this takes me to the very important book by oh yeah, Immanuel Kant, Towards Perpetual Peace in 1795. He wrote very interesting. He had witnessed the war between Persia and France, and then said कि perpetual the peace cannot permanent peace can be achieved. Then he gave three conditions. कि permanent peace can be achieved only if these three conditions are followed. Otherwise, the every efforts to end the peace is a kind of truce where both parties are exhausted and tired. They said we can't carry the war for longer. So they enter in agreement. So that's why it says temporary. So the peace treaty, so intention is not to end the war. The peace treaties two parties are signing and they are themselves are violating. So that is permanent peace. If you rule of law, human rights, federalism, lot of things he has said is there. So it's a truce. If Israel, there are a number of cases. Israel, it's starting from 1914. Many wars have been fought. It ended with every time it ended with some agreement. We also similar agreement. We also ended. We have signed many agreements with Pakistan, but every time we go back and fight. So the peace treaties are there. Peace, that is the best way. I hope that peace become permanent peace. It's not permanent peace. It's a temporary because the both countries are tied or other circumstances which compel them to come to the table, negotiate and close. But intention to come back, intention to retaliate remains there, and that is happening is there. Agreement is always temporary, it's not final. And history is full of instances. We have First World War, we have Second World War, and we don't know. TV already showing we have going Hindi channel. I am not sure about Kannada channel, but Hindi channel every day, if you open in the evening, they are the first to predict Third World War we are going to face. I don't know when and how, but our journalists they are saying India is and I don't know why they are so much concerned about the global development, not the local development. I think one more question is there. It's not exception to Article 51, is not exception to Article 24, 2 paragraph 4 of the UN Charter. But generally, it's a question of state preservation. State says, so whatever the instrument emerge, some way it takes note of the state concern, because it's not, it has come on its own. It has come where 51 states participated, and of course 4 states played very important role in the drafting of the United Nations. So they look into there. So the idea is more as in a rarest of the rare cases, 51 should be invoked. So it's not accept in a sense. That is the reason I said every state has a right to self-defense independently exist internal. So that is the Article 51 is the recognition of the right to self-defense if a state existence is in the question, and that is in the domestic law as well as the international law. In both places, right to self-defense exists in that particular sense. And since Article 2, paragraph 4 talks about the prohibition against use of force, to balance that one in a limited, it's not indefinite, it's not the for the longer period, it's a very limited, as I said, it's not open ended, and that is how I also mentioned about the proportionality. uh, if the United Nations comes to know about the situation, then things will be your right to self defense cease to exist. It's a very limited in there. Over to you, sir.
Sir, one more question, sir. Sir, can you give your opinion on shared natural resource in international environmental law?
Natural, state has sovereign state has a power to exploit the natural resources, and that is principle 21 of the Stockholm Declaration. The Stockholm Declaration, that is the wrong point also. But now perception is shaping, the concept of sustainable development, interdependence is there. But when it comes to exploitation and exploration of the natural resources, the first environment document that was signed in 1972, Stockholm Declaration, principle 21 makes the sovereign has full power to exploit the natural resources. That I believe, how to limit, and there gradually the concept of sustainable development, I think WCED, World Conference on Environment and Development, which was constituted in 1983 by the United Nations General Assembly, where 21 states participated. And then Our Common Future, the report which was submitted in 1987, Our Common Future, and Brundtland report, that popularly known as Brundtland report in 1987. There, the concept of sustainable development. So natural resources also has a limit. You you consume, but same time you leave the future. Like it should not compromise with the use of the future generation. So naturally, state has absolute right, but states should be careful in using the natural resources, not to sustain the only the present generation. It live also with that. So some kind of limitation has come from the 1987. Our common future is there, but sovereignty has power of the nature. Human rights instrument recognizes, environment instruments also recognize.
Thank you, sir.
Huh.
So, thank you, sir, for your valuable insights on perspective in international law. As you rightly pointed out, law without organization is incomplete. And in today's session has reminded us how global cooperation, structural institution, and rule-based system are essential for international legal order. Thank you, sir. We sincerely thank you for your time and meaningful contribution for this FTP. I would like to thank our Dean Sir, our Director Sir, all the participants, all the faculty members for your continued support and participation. Thank you all.
Thank you, sir. Thank you.